As introduced, my name is Ann Johnson, and I'm an attorney from Houston, Texas, and it is an honor to speak with you about the BW case and the impact that this child's case has had on not only changing how we will help and protect children in Texas, but how we will help children in the nation, because this was a case of first impression that all of you in this room that I know work in Austin and work on the laws that impact these children can be proud of what the Texas Supreme Court has done in helping not only Texas children, but the nation. This case actually started back in January of 2007, when a 13-year-old child was found on the streets agreeing to sex for a fee. This is not an isolated incident, and some of you may recall that before the Super Bowl was played in Dallas, that the Today Show did a segment on child trafficking. And you may remember this very visual image of a young, heavy-set Hispanic girl who was talking about when she was living in her home in Mexico, and they showed photos of her at a smaller, skinnier age, when two men came to their town in business suits and said that there was this great opportunity that they were going to be brought back to the United States and they were going to have an opportunity to work in a factory and that they'd be able to send money home to their families. And she talks about how their family felt like they'd won the lottery. And then they then show her in present day time beginning to cry as she describes that when she got to the United States, she was taken into a room, an older man came in, and he said that he was going to show her what it meant to be a woman. And she said she didn't know what that meant. And she begins to cry as she talks about how he takes her clothes off and then rapes her. She was discovered by the police, and she was protected when she was picked up in a raid of this cantina, along with many other children who had been subjected to prostitution throughout their time in Houston. That is an international victim, and many people have thought that human trafficking was just an international issue. BW represents the domestic side. This was a 13-year-old child who agreed to sex for a fee. She was a domestic child who was actually a CPS runaway. And when she was brought into the system, she originally was filed and charged as an adult. But upon discovering that this person was really just a 13-year-old child, what they did is they dismissed the case in the adult court and they simply transferred her for prosecution into the juvenile court. And so that's where we got into this disagreement. And I will tell you, my history is as a prosecutor in Harris County. And I recall trying cases and being in the felony court. And in the felony court, when a child was the victim of an aggravated sexual assault, it did not matter what the reason was. It didn't matter if she says, I love my boyfriend and I agreed to do it even though he's 25 years old and I'm 13. The law was always the same. The child cannot consent to sex regardless of the reason. And so that was the dispute. It was not over the facts. Everybody agreed this 13-year-old child had agreed to sex for a fee, but the question was, how were we going to apply the treatment? Were we going to treat her out of the criminal code, or were we going to recognize the family code? And that's where we get into this question of BW, which is a very specific and very narrow question that was presented to the Texas Supreme Court. And that was whether the legislature, by its wholesale incorporation of the penal code offenses into the juvenile justice provision of the family code, intended to permit prosecution of a 13-year-old child for prostitution, considering its specific pronouncement that a child under 14 is legally incapable of consenting to sex with an adult. And you can see that this argument was rooted in existing case law and existing statutes in both the family code and the penal code. And that was the question, do we place this child on a prosecution train or do we place this child on a protection train? The court, in ruling in BW's favor, found that we are to place these children on a protection train, recognizing this notion that an underage child cannot legally consent to sex is of long-standing origin. It derives from our common law, and Texas follows the majority of states which have established a two-step scheme that differentiates between sex with a younger child and sexual relations with an older teen. The rule's underlying rationale is that younger children lack the capacity to appreciate the significance or the consequences of agreeing to sex. The court went on to say that it is difficult to reconcile the legislature's recognition of this special vulnerability of children and its passage of laws for their protection with an intent to find that children under 14 understand the nature and consequences of their conduct when they agree to commit a sex act for money, or to consider children quasi-criminal offenders guilty of an act that necessarily involves their own sexual exploitation. In looking back at these statutes and these provisions, you will see here that the prosecution was taking a very simple approach, which was the family code says everything in the penal code applies, and section 4302, the definition of prostitution, can be used. And the argument that the BW was making and that the court agreed with was we can't just look at this in a vacuum, you have to look at these other provisions. And when you look at the penal code through chapters 21 and the assaultive sections, you will see that the law clearly establishes that if the child had actually performed the act agreed to, she would automatically be the victim of an aggravated sexual assault of a child. And so it was this question of how can we as a state, in essence, tell the child, if you perform the act, we will protect you as a victim. But if you just agree to it, then we're going to prosecute you as an offender. And the court agreed that that did not make sense in recognizing it that way. The court also recognized this issue with the children. And in this case specifically, BW, when she was brought into the juvenile court, was evaluated, and it was discovered, as the court recognized, she was an emotionally impoverished, discouraged, and dependent adolescent. She was exhibiting patterns of feeling sad, downhearted, unworthy, and she was yearning for acceptance from others, although her hopes appeared to be waning rapidly. It was also discovered, and later as the court found out in argument, that the child was also mentally deficient. She had also made an outcry that she was living with and having sex with her 32-year-old boyfriend. Part of the argument in this case was there is also an obligation, and there's an obligation in these same protective statutes of the penal code that a child may be compelled into prostitution. And if the child is compelled into prostitution, then the child is immune from prosecution. And so part of the argument was the focus in this case should have been targeted towards the adults involved and whether or not she was the victim of being compelled into prostitution. The court recognized that children are victims. They are not the perpetrators of child prostitution. The court went on to recognize that children do not freely choose a life of prostitution, detailing that experts have told us the extent to which they may be manipulated or controlled by others. The legislature in 2009 received a report on human trafficking as a modern-day form of slavery, Texas having 20% of the market in the United States, and Houston currently the world's largest center for human trafficking. The legislature also recently received last session an additional report, and it talks about the fact that the Texas Department of Criminal Justice did an evaluation of who was actually sitting in state facilities. And I would ask, how many of y'all have ever come in contact with a child that has been charged with prostitution, other than this case, or have heard from it? I know there are a couple back here, and I'll tell you, when I have given this presentation at the Juvenile Law Conference, when I ask that same question, just about everybody in the room raises their hands. And part of that is because this case was dealing with this provision which had been in existence since the 70s. And the theory that the prosecution had, and that I had been told in court, was this is just the way that we've done it, and this is the way that it works, and the way that we're going to continue to do it. And so many of us who have represented children in the juvenile court, either at a prosecution level, a defense level, and or with court staff with probation, just about all of us have come in contact with a child that has been brought through the system on a charge of prostitution. Yet we know from last session, from the report from the Texas Department of Corrections, at the same time that this legislature passed this provision in the 70s that the prosecution was using, there was also that provision of compelling prostitution, which carried a 2 to 20-year sentence. And last time, when looking at the statistics, there were only 10 adults statewide who were sitting in state prison having been prosecuted for compelling a child into prostitution. Yet at the same time, in my short practice as a juvenile defense attorney, I have come in contact with at least that number of children who have been prosecuted. And so part of this case was trying to change this perception, or if you will, just move this ship and turn it from viewing the child as a offender to recognizing and viewing the child as a victim. The State Department has also told us for every one that we have seen and identified, we are only coming in contact with 0.4% of those in existence. So for every child that I have seen, just to know that there are 200 more that we are not helping within the system lets us know that there's more work that needs to be done. Justice O'Neill, in writing this opinion, and in fact she told the Texas lawyer when she retired that she was retiring on this case because this case had so many of the issues that were important to her with regard to juvenile justice and access to court. And in looking at this opinion, you can see that the Texas Supreme Court was very thoughtful about what they were telling us on how we could move forward. And there's just a small change in language. Because the reality is, we cannot solve this problem. We can't even begin to tackle it without the involvement of police officers and without the help of vice departments. And BW illustrates that because this was 10:30 a.m. on a Tuesday morning. A 13-year-old child who should normally be in school was standing on a street corner, agreeing to an undercover officer for sex for a fee. She wasn't in school where she should be. She wasn't in the proper placement where she should be. And that raises those additional questions, why not? And who had possession of her or who was keeping her, if you will. The court recognized the outcome of this case is not to say, just let the child go on about their business when you find them and they agree to sex for a fee and they say, oh, I'm really 12. Don't say, oh, well, you're 12, I can't do anything about this anymore, see you later. The court said, no, you need to be involved, but police officer, we're going to call it something different. You need to take that child, you need to put that child in your police car, but rather than driving that car to the Juvenile Justice Center for an arrest, you need to take possession. And take possession is the term that is used out of the Family Code, where the court recognized a law enforcement officer may take possession of a child without a court order if a person of ordinary prudence and caution would believe there's an imminent danger to the physical health or safety of the child and that the child has been the victim of sexual abuse. The court recognized the fact pattern in BW that certainly meets that definition. And so the officer in this case needed to do exactly what they did. Take the child, put them in their police car, and make sure that they're taking them to an appropriate place. The court went on to say you don't just stop there. Law enforcement or another appropriate agency shall make a prompt and thorough investigation of a report of child abuse. And so presumably the next step should be that the law enforcement officer should say, where have you been living for the last 14 months? Why aren't you in school? Where have you been getting your food? Who's been taking care of you? And the appropriate reason to do that is to move forward with doing what the law tells us, which is to prosecute the pimps and the johns that are exploiting the children. We can see from the history that that has not been taking place. I know things are moving in a different direction now, and there's beginning to be progress, and I do want to talk to you about that progress. Unfortunately, as I mentioned, this key phrase of arrest versus take possession. After this case, there was kind of a backlash to people saying, look, we need to be able to arrest them. And you can arrest them if you'll let me call the child a chins, meaning this child is committing conduct indicating a need for supervision. But there are two different tracks by which you can bring a child into juvenile justice. One is delinquent conduct, meaning the child is committing a penal code offense. They've committed an assault, aggravated robbery, anything else that you can think of that if an adult committed the offense, they could be incarcerated and put in jail. On the other side, there's this other provision of chins, which means the child is doing something that's not really good for them, like they've run away from home, or they're truant and not going to school, but they're not doing something that the law would say if an adult was doing, they could be confined in jail. And so this is part of the issue that we get into with a current provision redefining these children as a chins. And there has been a dispute among counties of what can we legitimately do with them. I'm from Harris County. And in Harris County, looking at these provisions of the family code, you may not detain a child on a chins. You can arrest them, you can bring them to the juvenile detention center, but you've got to let them go within 24 hours or 72 hours, depending on whether or not you've got a weekend, or you may be able to get one 72-hour extension. That does not provide the essential thing that is needed, which is to take possession. Because then if you have to let the child walk out the door, where are they going to go? And it comes right back to the same argument, which is you need a system that is there in existence and put in place for children. The family code is that vehicle. And the family code definition protects children from the ages of 0 to 18. The other issue with trying to put them back in the juvenile justice code is you're dealing with children that we're now limited to 10 to 17. So what do we do with the 9-year-olds? What do we do with the 8-year-olds? What do we do with the 17-year-olds? And you may be saying, okay, Ms. Johnson, I know you're talking about a child from 13, but 9 and 8, I'm not buying it. All you have to do is look at the case of the child out of North Carolina, and you may remember the report where they showed a few years ago the image from a hotel room of a man physically carrying in his arms a 5-year-old little girl. And it was surveillance video of her when she was still alive. They later found Shania Davis dead. And her mother and that pimp were charged with pimping and kidnapping. This is a reality that impacts all children, which is why there is a need to make sure that the law is staying in place to protect all of them through the vehicle which recognizes them as the victims that they are in the family code. While there's been great work that has taken place, I also want to tell you about something that's happening in Harris County, and I know that this is going to come up in the next presenter, and that's the girls' court in Harris County. I'm proud to say that I'm one of the attorneys that works on that court. Judges Mike Schneider and Angela Ellis, in seeing the need in Harris County, and seeing what has happened with the BW case and this transition and this recognizing that these children are victims and not offenders, there is a new court that's been created, and that's one of the alternative courts, just as a mental health court or the drug court or the gang court, and it is specifically put in place for the children that are coming into the system where they are, in essence, a trafficking victim, or there are the red flags of them being subjected to human trafficking. Because many of these children that come through, when they come through on a charge of prostitution, it's almost easy to say, okay, we know. But many of them come in for failure to ID, or criminal trespass, or drug possession. And so this court is now recognizing and bringing these children in and working in conjunction with other groups. In fact, Children at Risk has been essential, and what you all may know about is Freedom Place. And Freedom Place is a new safe house that's been created, working in connection with the court to try to provide this placement and services for these children that are coming through the system, and a recognition of them as victims as opposed to offenders. I'll tell you that the court is working, and that the court is a work in progress, but the court is also full. And at the same time that Freedom Place is in existence, it's one small component that's happening in Harris County, but there's got to be a recognition that these are not the only children that are being subjected to this kind of devastation statewide. And so there is a great need to make sure that the progress that has been made in BW, and that the progress is being made with Children at Risk in the Attorney General's office, in the new courts continues to move forward so that we can provide more protections, the adequate protection and the right protection for these children as victims as opposed to offenders.